Again, principles surrounding sovereignty, such as non-intervention, are essential in the maintenance of a reasonably stable system of competing states. Setting limits on the powers of states compared with other states contributes to some extent to a degree of stability within the legal order. Stability is stability is one of the one of my lessons. Stability is stability is is another lesson of mine. Yeah. Equality. One other crucial principle is the legal equality of states, that is, equality of legal rights and duties. States, irrespective of size or power, have the same juridical capacities and functions, and are likewise entitled to one vote in the United Nations General Assembly. This was recognized in the 1970 Declaration on Principle of International Law. Within the General Assembly of the United Nations, the doctrine of equality is maintained by the rule of one state, one vote. However, one should not overlook the existence of the vote possessed by the USA, Russia, China, France, and the United Kingdom in the Security Council. Sovereignty of states over territory. Sovereignty is the exclusive right to exercise supreme political authority over a defined territory, land, air, space, and certain maritime areas, such as the territorial sea, and the people within that territory. No other state can have formal political authority within that state. Therefore, sovereignty is closely associated with the concept of political independence. Since a state has sovereignty within its territorial sea, with some exceptions, such as the right of innocent passage, it's an important one, it has the exclusive authority to exercise police power within its territorial sea. For example, if foreign ships are attacked by pirates in the territorial sea of a state, the only state that can exercise police power and arrest the pirates in the territorial sea is the coastal state. Yeah, that's logical, I think. United Nations, UN. The powers of the United Nations are set out in the United Nations Charter of 1945. General Assembly, one of the 6 principal organs of the UN, and the only body in which every member of the organization is represented and allowed to vote. The General Assembly is the main deliberative, policymaking, and representative organ of the UN. Decisions on important questions, such as those on peace and security, admission of new members, and budgetary matters, require a two-thirds majority. Decisions on other questions are by simple majority. The Security Council has the authority to make decisions that are binding on all member states when it is performing its primary responsibility of maintaining international peace and security. The Council is composed of 15 members: permanent members China, France, Russian Federation, the United Kingdom and the United States of America, and 10 non-permanent members elected on a regional basis to serve 2-year terms by the General Assembly. Minutes maximum. So, the ECOSOC serves as the central forum for discussing international economic. By the way, I'm passing those parts. I spoke when the audio is paused. Yeah. So I'll continue. Yeah, and for formulating policy recommendations addressed to member states and the United Nations system. International Labour Organization (ILO). ILO's main purpose is to raise world labor standards by building up a code of international law and practice. It forms policies and programs to help improve working and living conditions, enhance employment opportunities, and promote basic human rights. Each of the specialized agencies was integrated into the UN system by way of an agreement with the UN under UN Charter Article 57. International Maritime Organization (IMO). IMO provides machinery for cooperation among governments in the field of governmental regulation and practices relating to technical matters of all kinds affecting shipping engaged. My ass in pain. Yeah. Shipping engaged in international trade. Blah blah, encourage and facilitate the general adoption of the highest practicable standards in matters concerning and control of marine pollution from ships. Oh good. Yeah. IMO consists of an assembly and council and 5 main committees. The Maritime Safety Committee, MSC, the Marine Environment Protection Committee, MEPC, Technical Cooperation Committee. Yeah, we just have to know its name. The Marine Environment Protection Committee. The Marine Environment Protection Committee, which consists of all member states, is empowered to consider any matter within the scope of the organization concerned with prevention and control of pollution from ships. In particular, it is concerned with the adoption and amendment of conventions and other regulations and the measures to ensure their enforcement. The MEPC was first established as a subsidiary body of the Assembly and raised to full constitutional status in 1985. Conventions, protocols, amendments, recommendations, codes and guidelines, and resolutions. Yeah. Maritime safety, efficiency of navigation, prevention and control of marine pollution from ships. IMO consists of an assembly and council and 5 main committees: Maritime Safety Committee, the Marine Environment Protection Committee. Protocols. Protocols are important treaty instruments made when major amendments are required to be made to a convention which, although already adopted, has not yet entered into force. The Solas Convention 1974 has been amended twice by means of protocols by the 1978 Solas Protocol, which entered into force on 1 May 1981, and by the 1988 Solas Protocol, which entered into force on 3rd of February 2000 and replaced and abrogated the 1978 Protocol as between parties to the 1988 Protocol. The combined instruments, formerly known as SOLAS 74-78, are now collectively called SOLAS 74-88. Amendment. In the case of the 1974 SOLAS Convention, an amendment to most of the annexes, which constitute the technical parts of the convention, is deemed to have been accepted at the end of 2 years from the date on which it is communicated to contracting governments, unless the amendment is objected to by more than 1/3 of contracting governments, or contracting governments owning not less than 50% of the world's gross merchant tonnage. International crimes, genocide. It's a fucked up thing, yeah, I know. The International Criminal Tribunal for the former Yugoslav is a United Nations court of law dealing with war crime that took place during the conflicts in the Balkans 1990s. Since its establishment in 1993, it has irreversibly changed the landspace of international humanitarian law and provided victims an opportunity to voice the horrors they witnessed and experienced. In its precedent-setting decisions on genocide, war crimes and crimes against humanity, the tribunal has shown that an individual's senior position can no longer protect them from persecution. A. Murder. B. Extermination. C. Enslavement. D. Deportation. E. Imprisonment. F. Torture. Those are all bad things, yeah. Under the 1969 Vienna Conventions on the Law of Treaties, a treaty must be a binding instrument, which means that the contracting parties intended to create legal rights and duties concluded by states or international organization with treaty-making power, governed by international law in writing. The instrument of ratification, a formal sealed letter referring to the decision and signed by the state. Responsible authority. State of responsible authority. Is then prepared and deposited with the United Nations Secretary General in New York, providing for signature, subject to ratification, allows state time to seek approval from the treaty at domestic law and to enact any legislation necessary to implement the treaty domestically prior to undertaking the leg obligations under the treaty at the international level. Once a state has ratified a treaty at the international level, it must give effect to the treaty domestically. This is the responsibility of the state. Generally, there is no time limit within which a state requested to ratify a treaty which it has signed. Upon ratification, the state becomes legally bound under the treaty. International community, a state's commitment to undertake the obligations under a treaty should not be confused with certification at the national level, which a state may be required to undertake in accordance with its own constitutional provisions before it expressed consent to be bound internationally. Certification in the national level is inadequate to establish a state's intention to be legally bound at the international level. The required actions at the international level shall also be undertaken. The instruments of acceptance or approval of a treaty shall the same legal effect as ratification and consequently express the consent of a state to be bound by a treaty. In the practice of certain states, acceptance and approval have been used instead of ratification when, at a national level, constitutional law does not require the treaty to be certified by the head of the state. Accession is the act whereby a state accepts the offer or the opportunity to become a party to a treaty already negotiated and signed by other states. It has the same legal effect as ratification. Accession usually occurs after the treaty has entered into force. The Secretary General of the UN, in his function as depositary, has also accepted accessions to some conventions before their entry into force. Articles 2.1b and 15 Vienna Convention on the Law of Treaties 1969. In certain cases, states make Statements upon signature, certification, acceptance, approval of, or accessions to a treaty. Such statements may be entitled declaration, understanding, declaration, reversation, understanding, interpretative declaration, or interpretative statement. However, phrased or named, any such statement supporting to exclude or modify the legal effect of a treaty notions with regard to the declarant is, in fact, reservation. Reservation may enable a state to participate in a multilateral treaty that the state would otherwise be unwilling or unable to participate in. Upon a certain number of states depositing instruments of ratification, approval, acceptance, or accession with the depository. Upon a certain percentage, proportion, or category of states depositing instruments of ratification, approval, acceptance, or accession with the depository. A specific time after a certain number of states have deposited instruments of ratification, acceptance, approval, or accession with the depository on a specific date, such as negotiation, consultation, conciliation, use of good offices, panel procedures, panel procedures, arbitration, judicial settlement, reference to the international court justice, etc. Adoption is the formal act by which the form and content of a proposed treaty text are established. I think he's coming. I don't like him. Yeah. So we pause it here.